and we are being told that the Aam Aadmi Party will be moving Supreme Court. जी पुलकित,
देखिए, आम आदमी पार्टी की तरफ से साफ कर दिया गया है कि वो इस फैसले के खिलाफ सुप्रीम कोर्ट जाएगी और ये हो सकता है कि कल ही आम आदमी पार्टी के वकील सुप्रीम कोर्ट में इस मामले की याचिका दाखिल करें कि वो हाईकोर्ट के इस फैसले के से संतुष्ट नहीं है और गिरफ्तारी को चुनौती देने वाली याचिका कल हाईकोर्ट में सुप्रीम कोर्ट में लेकर पहुंचे। जी
पुलकित, भारतीय जनता पार्टी का यह कहना है कि अब हाईकोर्ट के फैसले के बाद अरविंद केजरीवाल को तुरंत इस्तीफा दे देना चाहिए। क्या इस पे आम आदमी पार्टी से कोई प्रतिक्रिया आ रही है?
देखिए, अभी 4:30 बजे आम आदमी पार्टी प्रेस कॉन्फ्रेंस करने जा रही है जिसमें वो बीजेपी के आरोपों का या सवालों का जवाब देगी, लेकिन पार्टी सूत्र यही कहते हैं कि वो अरविंद केजरीवाल किसी भी कीमत पर इस्तीफा नहीं देंगे, ना ही पार्टी के नेता उनसे इस्तीफा एक्सेप्ट करेंगे। अगर वो देने के लिए कहते भी हैं तो विधायक और पार्षद इस बात के लिए राजी नहीं होंगे। हालांकि अरविंद केजरीवाल खुद भी अभी इस्तीफा नहीं देना चाहते हैं। पार्टी की रणनीति पूरी तरीके से इस्तीफा न देने की है। जी
Okay, thank you for that quick update. Bhavtosh, let's talk about the couple of interesting observations. One, the court said that doubting integrity of approvers is, it amounts to doubting the majesty of the court. The second rap for Arvind Kejriwal was when the court said that let's not get into poll bonds and other things. Let's not confuse issues.
Yes, there has been this continuous argument not only by Aam Aadmi Party but by several places in individuals where they had said that just because Sharad Reddy was arrested in this case, he gave Aurobindo Pharma purchased electoral bonds worth 50 crore rupees which went to Bharatiya Janata Party. They linked that matter and then subsequently said that he turned approver, and they said that because he turned approver in this case, he was given pardon by the court. To which Justice Kanta Sharma said that his statement was recorded by a judicial magistrate and that happened in a closed room, and that he could have told that he was being coerced, and the court also said that this is a century-old practice, and by raising doubts about this entire process, you are raising doubts about judiciary. The second point that she has said that because the arrest has taken place when model code of conduct has been placed, this point is invalid primarily because Arvind Kejriwal is the one who has been skipping summons. We have to again wait for the written order because these are oral observations that have been made in the court. Importantly, what I was telling earlier, Pranesh, is the fact that the court has again said there is a material evidence to show that Goa election, at least the campaign of Goa election by Aam Aadmi Party, was funded in cash through Hawala, and this is the point that has been continuously stressed by the Enforcement Directorate right from November 2022 when the first charge sheet in this case has been filed. Though Aam Aadmi Party and many others have completely debunked this, even Additional Solicitor General S.V. Raju in one of the hearings has said that they cannot show any kind of money recovery in this case because that money has completely been spent. Though the agency claims that they have a documentary evidence to show that Goa election campaign at least was funded by Hawala operators up to 45 crore rupees, 100 crore kickbacks were paid by the South Group, of which 45 crore rupees was used in the Goa Assembly election.
Okay, now Bhavtosh, we're given to understand that in about 10-15 minutes, and Pulkit was telling us that Aam Aadmi Party is likely to hold a news briefing. We will know more in that what the AAP intends to do from here on. But let's talk about other major observations. The court said that the law is same for the Aam Aadmi as also for the Chief Minister.
Yes, Pranesh, the point that was being raised by the Enforcement Directorate in the hearing is that the first summon was issued to Arvind Kejriwal on 30th of October, on the day when Manish Sisodia bail was rejected by the Apex Court. And then their last summon was issued for 12th of March, or in the second week of March, and that he was in fact been given prior notice, and at least he was being told to join the investigation. Now, the issue here, at least for Abhishek Manu Singhvi, was the timing of the arrest. He in fact told the court that the whole idea was to arrest him so that he does not campaign in the election, whereas the Enforcement Directorate has said that he could have come and joined the investigation way back in November 2023. 2023.
Bhavtosh, allow me to bring in Swapnil Kothari. Advocate needs no introduction. Mr. Kothari, thank you for speaking to us. I'm sure you were following the arguments on Times Now. What do you make of it? Make of what the court said?
Pranesh, it's very, very clear that the court is interested in constitutional morality and not political morality. It has made very clear that it has no business entering the political arena. The bottom line is whether Enforcement Directorate has a case, whether it has sufficient material evidence on hand to show that Mr. Kejriwal needs to be in the dock. Once it is established by the Enforcement Directorate that they have ample material and Mr. Kejriwal's hands were in the cookie jar to prima facie, then there is no question of entertaining Mr. Kejriwal's plea. The argument that this is the timing of the arrest is illegal or the timing of the arrest is politically motivated so that he cannot campaign for the election, so that Mr. Modi does not have any opponent as far as the prime ministerial candidacy is concerned, all of these things do not work in a court of law. What works in a court of law is that whether or not there is prima facie case of money laundering against Mr. Kejriwal, whether he was part of the larger conspiracy along with the ones that have already been arrested and who took a long time, at least one of them to get bail eventually. So the point is very simple. That is where the court has laid its emphasis on. And I would suggest that Mr. Kejriwal's team does not even bother going to the Supreme Court because they're going to meet the same fate. Now, it's very simple that you fight it out in the trial court the way you had decided it earlier. And on that basis, you can try to establish evidence. And unfortunately, what happens, Pranesh, is that in fiscal offenses like money laundering, the onus is on you. For example, if I have avoided income tax, if I have evaded income tax rather, and the income tax commissioner sends me a notice, I have to prove that this is not income and this is why I have not evaded income tax. It is not, the burden of proof shifts on me. So the burden of proof is on Mr. Kejriwal to show that the money that was there in his hands was not laundered. It was a legitimate source of income. So it's not for the ED to prove as much as it is for Mr. Kejriwal to show that he's not legally liable to that extent under the PMLA. The rigors of PMLA are very, very serious. And if you recall, quite a few months ago, maybe a year ago, there was a 3-judge Constitution Bench decision which clearly allowed the PMLA to be in the form that it is in. So to say that it's a draconian law, yes,
Mr. Kothari, as an advocate, I want to understand from you, when the High Court said that doubting a prover amounts to doubting the court, what does it mean?
Well, the point is very simple, because every time the allegation is made that Mr. Kejriwal has been arrested and his custody is being enforced, it's being continued, etc. So in essence, what it is doing is what the person who's making the plea, Mr. Kejriwal's team or Mr. Kejriwal himself in this case, is that there is some sort of a subtle innuendo to that effect that there is some fanciful play or foul play by the court, because it's the court which grants custody. It's the court which extends the custody. So the court is making it very clear that we are governed by the law. We are governed by the principles of the law. We are governed by Criminal Procedure Code. We are governed by the Indian Penal Code in its new form, CRPC in its new form. And that is what is going to prevail at the end of the day. So do not cast aspersions on us. So it's maybe taken it, and I would suggest that the team takes it as a subtle warning, because tomorrow you don't want to be saddled with contempt, and much more less than that, some sort of a prejudice in the minds of the judge when you stand before that same judge in a separate matter where the court does remember, and trust me, judges and the courts have elephantine memories.
Thank you, Swapnil. Very comprehensive indeed for putting this into perspective for our viewers. Bhavtosh, the kind of political commentary that we've seen in the case from witch hunt, vendetta and whatnot, one wonders what will the Aam Aadmi Party say in the news briefing that's about to start in about 8 minutes from now?
Well, right from day one, once the Enforcement Directorate registered the money laundering case that happened on 23rd October 2022, they've always said that Center has been targeting them by letting loose both the Federal Probe Agency, be it CBI, as well as by the Enforcement Directorate. But remember, this case has its fair share of controversy and fair share of drama. The manner in which some arrests have taken place, and also the manner in which Sanjay Singh got bail, the Enforcement Directorate did not even oppose, did not even submit any kind of written submission. That, in fact, was the only good news that has happened as far as the Aam Aadmi Party is concerned. Otherwise, most of their leaders have not managed to get any kind of relief or reprieve as far as this case is concerned.